Hi there, and welcome to the first installment of our webinar series for 2023. This month, we're going to be talking about sexual assault and the justice system. Just a few housekeeping things before we get started. As usual, I would like to send a warning. Some of the content that you're about to hear might be upsetting, so please practice good self-care and step away or pause the playback if you need to. And also, we would like to acknowledge that the Women's Resource Center is located on Treaty 2 territory, and we also operate on Treaty 1 territory as well, which are the lands of the Anishinaabeg, Cree, Oji-Cree, Assiniboine, Dakota, and Dene peoples, and these lands are also the homeland of the Red River Métis Nation. As always, we're going to start off with some definitions. So I'm going to start off by defining sexual assault. And the reason that I continue to do that throughout almost all of the webinars that I've done is because it has been found actually that a lot of people are fuzzy on what the definition of sexual assault is, what constitutes sexual assault. And that unfortunately turns into situations where if somebody does experience a sexual assault, then they're more willing to not classify it as that. So in order to kind of combat that, I'm going to keep defining it, including in today's presentation. So provisions covering sexual assault in the Criminal Code of Canada hinge on two main ideas, which is consent and rules governing all types of assaults apart from sexual assaults. So general assault is defined under the Criminal Code as when a person commits an assault when, without the consent of another person, he applies force intentionally to that person, directly or indirectly. He attempts to threatens by an act or by a gesture to apply force to another person if he has or causes that other person to believe on reasonable grounds that he has present ability to effect his purpose, or while openly wearing or carrying a weapon or an imitation thereof, he accosts or impedes another person or begs. So that is the definition of general assault under the Criminal Code. And that notion is tied to the idea of consent when we're talking specifically about sexual assault. And the Criminal Code also defines what constitutes consent in general, and also what defines consent in terms of sexual activity. So the general definition of consent is as follows. For the purpose of this section, no consent is obtained where the complainant submits or does not resist by reason of A, the application of force to the complainant or to a person other than the complainant, threats or fear of the application of force to the complainant or to a person other than the complainant, fraud, or the exercise of authority. So I think what this definition does particularly well is it doesn't only outline what consent is, it outlines where consent is not obtained. And it also says that consent is not obtained where the complainant does not resist. So it's kind of saying that kind of idea of the absence of a no is not a yes. So just because somebody didn't resist doesn't mean that they consented. And that's really important when we're talking about sexual assault. Further, specifically relating to sexual activity, the Criminal Code also has something to say about that. So that definition is as follows. Subject to subsection 2 and subsection 265.3, consent means for the purposes of sections 271, 272, and 273, the voluntary agreement of the complainant to engage in the sexual activity in question. So consent must be present at the time the sexual activity takes place. And for the purposes of subsection 1, no consent is obtained if A, the agreement is expressed by the words or conduct of a person other than the complainant, or the complainant is unconscious. B, the complainant is incapable of consenting to the activity for any reason other than the one referred to in paragraph A1. C, the accused induces the complainant to engage in the activity by abusing a position of trust, power, or authority. D, the complainant expresses by words or by conduct a lack of agreement to engage in the activity. Or E, the complainant having consented to engage in sexual activity expresses by words or conduct a lack of agreement to continue to engage in the activity. So again, what this definition does well is it reiterates that idea of the absence of a no is not a yes. So it it gives an overview of situations where somebody might not necessarily say no, but they also haven't said yes. So, for example, if somebody is abusing a position of trust, power, or authority, that might create a situation wherein somebody feels that they are unable to say no to sexual activity, but they're also not saying yes. So that would constitute a sexual assault. Also, it notes that body language is also something that needs to be paid attention to when we're talking about consent. So again, just because somebody doesn't say no with their words, if they say no through their body language, that is something that needs to be considered as well. In discussions of consent, and it also notes that just because somebody agrees to sexual activity in one situation, it doesn't mean that they've agreed to either participate further in that sexual activity or to participate in another type of sexual activity. So the criminal code definitions have been distilled generally down into this kind of definition that centers like ours use that are just more generally used in society. So the definition that we generally use at our center is sexual violence is any sexual activity, behavior, contact, or touching that makes you uncomfortable and or that you did not consent to. Being pressured, manipulated, coerced, or threatened into engaging in unwanted sexual activity or contact, being unable to give consent to the activity because you were asleep, unconscious, or intoxicated, and it includes things like forced kissing, fondling, oral, anal, or vaginal intercourse. So yeah, those are the aspects that are part of the definition of sexual violence and sexual assault that we use at the center that are in line with the criminal code definitions of sexual violence that would be used in a court of law setting. And we're going to be getting into that court of law setting in a minute because that is the topic of today's webinar. Okay, so now that we've talked about some of the definitions that are going to be relevant to talking about sexual assault in the justice system, let's talk some stats. So stats on perpetrators of sexual assault are as follows. So approximately 94% of the time, perpetrators of sexual assault identify as male. Between the ages of 18 to 34, usually 58% of the time. 79% of the time, the perpetrator acted alone. 56% of perpetrators knew the person that they were assaulting. 24% of the time, perpetrators are the spouse. 19% of the time, the perpetrator is an intimate partner. So these stats speak to a few things. One, this 79% of the time the perpetrator acted alone statistic kind of busts the myth, the very common myth, unfortunately, that sexual assault is a crime of opportunity perpetrated by strangers on strangers. So often sexual assault carries that connotation of stranger danger, that it occurs in situations where people are out by themselves and somebody kind of jumps out of the bushes, so to speak. But that kind of sexual assault trope really just isn't accurate when you look at the numbers. As you know, 56% of the perpetrators knew the person they were assaulting, and 79% of the time the perpetrators acted alone. And also these stats speak to the overlap, you would say, between sexual assault and domestic violence. So sexual assault is a type of domestic violence, and as we see in these stats, 24% of the time sexual assaults are perpetrated by the spouse, and 19% of the time the perpetrator is an intimate partner. So that's a pretty huge proportion of sexual assaults that are perpetrated by either a spouse or an intimate partner. And usually when sexual assault is perpetrated as a type of domestic violence, that's not the only type of domestic violence that is being perpetrated at the time. It's usually happening in tandem with things like other types of physical abuse, emotional abuse, psychological abuse, spiritual abuse, and financial abuse. We do have another webinar on different types of abuse, and we also have content on our Instagram page going over different types of abuse. If you'd like to familiarize yourself with those a little bit more, that information is out there. We'd also like to point out that a very small minority of sexual assaults are actually reported. And by reported, we mean reported formally to the police, where there's a record of it in the formal justice system. So approximately 5% of sexual assaults are reported in that way. And if those reports end up having charges laid and going through the court process, approximately 1% of those reports actually end up in any kind of conviction. And the reason why this number is so small, there's a lot of reasons why this number is so small, but some of the more common ones that survivors cite when deciding not to report are not wanting the hassle of reporting and going through the whole process of having to repeat the story multiple times to multiple different people, just the length of time that it takes going from reporting to taking a statement to the court process. That can be a huge deterrent for folks when deciding whether or not they want to report. Also, survivors feel that they won't be believed, and those fears are very much grounded in reality when we discuss the ways that the justice system interacts with survivors of sexual assault. Oftentimes, survivors are subjected to inappropriate questioning. There is often an air of disbelief when we're talking about sexual assault in the justice system, whether it's in the context of police reports or in the context of a trial. And that kind of feeds into the fear that survivors feel that they won't get any justice if they do report through the formal justice system. And again, that goes back to the statistic that I cited just a moment ago, where of the 5% of sexual assaults that are reported, approximately 1% actually yield any kind of conviction. So a lot of times survivors feel that they go through the whole hassle of reporting and having to recount this story multiple times in front of essentially strangers, and potentially enduring re-traumatization only to have nothing come of it, so to speak, in the sense that there would be no conviction or no sense of justice for the survivors. Survivors also tend to worry that their experience wasn't quote unquote serious enough. And that couples with the next kind of common reason, not defining what happened to them as sexual assault. It's actually been found that many people are unaware of what actually constitutes sexual assault. So they view, if something happens to them, a lot of times people don't view that as sexual assault when it is, or they think because it's not, the type of sexual assault that would be seen in like a movie or something, that it's not serious enough, and they don't want to take up the time of the folks in the system, when that's exactly what the folks in the system are there for. That's their job. And there's no such thing as a not serious enough sexual assault. If it's a sexual assault, it's serious enough. And it's also important to ensure that folks understand what constitutes a sexual assault and what doesn't, as I mentioned before, so that if they're ever in that situation, they know what constitutes a sexual assault and are able to categorize it as such. And survivors often feel as though they may be blamed for what happened to them or blamed for the assault that they experienced. And again, that is something that's very much grounded in reality, that is based on rape culture and rape myths, which we're going to talk about in a little bit as well. But there is a huge culture of victim blaming, unfortunately, within the formal justice system, specifically when it comes to sexual assault. And the last little piece on this slide here is when the survivor knows the perpetrator, they're nearly twice as likely to wait a longer period of time before reporting the assault. And as we have seen in the statistics above, a significant proportion of the assaults that are perpetrated by people that the survivor knows. So that would mean that a lot of the time, folks are waiting a significant amount of time before reporting if that's what they decide to do. So I would also like to point out that sexual assault often affects different groups of people in different ways. And this is mainly attributable to forces like racism and homophobia, biphobia, transphobia, ableism, sexism, and misogyny. We discussed the intersectional impacts of sexual assault in one of our previous webinars. That's available on our YouTube channel if anybody would like to have a look at that. But some groups that may experience higher rates of sexual assault include those with physical or intellectual disabilities who experience sexual assault at a rate approximately 2 times higher. Indigenous women and girls experience rates of sexual assault that are approximately 3 to 6 times higher. And those who identify as part of the 2S LGBTQ+ community experience sexual assault at a rate that is approximately 6 times higher than those who are not part of that community. So let's talk a little bit about misinformation rather, and rape culture, because these things unfortunately form a large part of the way that the justice system responds to issues of sexual violence and of sexual assault. So let's talk about rape myths. And rape myths are essentially, they are ideas that are prevalent in society that perpetuate misinformation about sexual assault in a way that makes it much more difficult for survivors to come forward with their experiences. So some common rape myths that we see specifically in the justice system are, for example, judges or lawyers questioning survivors about what they were wearing, or how much they had to drink, or why they were out so late at night. Those kinds of things are myths that put the blame for sexual assault on the victim, so victim blaming. And these myths are so common in the justice system, unfortunately, that it can make it really difficult for survivors to come forward after they have experienced an assault. And rape myths make it difficult for ideas of consent to kind of properly permeate society as well, because there are some rape myths that are unfortunately still quite prevalent, such as specifically in relation to the justice system, of course. Sometimes there will be questions directed at the survivor about, well, why didn't you say no? Why didn't you fight back? And the myth there is that if survivors don't say no or they don't fight back, then they actually did give consent, when that's so far from correct. So that's why being able to reconcile rape myths with ideas of consent is so important, because unfortunately rape myths do affect ideas of consent and plant incorrect ideas about what consent is and isn't, that unfortunately have infiltrated the justice system at various levels. So where do rape myths come from, and how do they keep getting perpetuated? Rape myths essentially come from misogynist and sexist ideas about sex and sexual assault. They come from long-standing ideas of inequality, and they keep getting perpetuated for one reason, is because it's not called out enough when it happens, unfortunately. So that's one of the ways actually that we can all work to stop rape myths from being perpetuated, is to call it out when you see it. So for example, just in a hypothetical situation, if you're watching the news with somebody and a case about sexual assault comes up, and the other person says, well, I wonder how much they had to drink that night, or I wonder what she was wearing, or any of those kinds of things, that's where people can step in and say, oh, that actually doesn't influence whether she consented to any kind of sexual activity. Somebody can still be sexually assaulted regardless of what they were wearing. And if somebody has been excessively drinking, then they're unable to consent to any kind of sexual activity. So calling out rape myths when we see them is a really important way that we can prevent rape myths from being perpetuated, and to kind of start to root out the misogyny and sexism that are at the base of where rape myths come from. And rape myths feed into what is called rape culture. And rape culture is a culture where sexual assault is normalized, unfortunately. And we see this in cases that become prominent in the news, for example. So rape myths do influence rape culture, they kind of work in tandem. So an example of a rape myth that props up rape culture would be that the myths surrounding consent. So did she fight back? Did she say no? Did she communicate it in any way through body language? That she was not consenting. And those rape myths, unfortunately, normalize sexual assault by planting disinformation about what consent is. So, by planting disinformation about what consent is, it's normalizing sexual assault when in reality, those ideas are erroneous and actually prop up sexist and misogynist ideas about sexual assault. And as we've kind of seen, all of those ideas are pretty prevalent within the justice system. There's actually a really excellent book written about how the legal profession unfortunately contributes to a lack of justice and a lack of process for survivors of sexual violence and sexual assault. It's called Putting Trials on Trial, and it's by Elaine Craig. I would highly recommend it if you're looking to get more information on, again, how the legal system and the legal profession in particular props up these sexist and misogynist ideas and rape culture and rape myths, specifically within sexual assault trials. So one process that is, I believe, under discussed when we talk about the justice system and sexual assault is that of third-party reporting. So oftentimes when we think of reporting a sexual assault, we think of reporting to the police. But unfortunately, that is not an option that's available to all people equally for a multitude of reasons. Lots of people don't feel comfortable talking to the police. They, might not be able to for whatever reason. So third-party reporting is another option. It's a way for those who have experienced sexual assault to report their experience without having to go directly to the police, and for those who are unsure if they want to pursue an investigation. So in Brandon, the Women's Resource Center and the John Howard Society are the only agencies in Brandon that currently offer third-party reporting services. And just to note that to make a third-party report in Manitoba, the reporter must be 16 years of age or older. So just briefly, the process of a third-party report would occur in the center, for example. So during the appointment, a staff member will sit with the survivor and assist them in filling out the appropriate forms and providing the necessary supports. When making a third-party report, it's important to note that personal and identifying details will remain with the staff member who takes the report. The survivor's personal information, names, addresses, phone numbers, email addresses, all that kind of stuff does not go to the police. So it's kind of a more anonymous way of being able to report, as that can also be a barrier for people who are wanting to have a record of what happened to them, but don't necessarily want to take it directly to the police. From there, the staff member will act as the intermediary between the survivor and the police in submitting forms on their behalf and relaying any questions to the survivor that the police may have. And once the third-party report is provided, a report number will be issued and kind of attached to the third-party report paperwork. But there are some important considerations when deciding whether or not a third-party report is the best option. So if a police want to speak with the survivor, the request must be provided in writing to the third-party reporting agency, and the third-party reporting agency will then contact the survivor and discuss the situation with them. The police can't contact the survivor directly. They don't have any personal or identifying information about the survivor, so that can cause the process to be a little bit more drawn out. But again, if a survivor is uncomfortable having direct contact with the police, then that might be a better option. The information within the report may be entered into the Violent Crime Linkage Analysis System, which is a national database that police use to determine whether there are any patterns or similarities in crimes. So it tracks things like locations, times, dates, and descriptions of offenders to determine whether or not there are any kind of patterns or similarities in crimes that might be useful. And it's also really, really important for me to reiterate that third-party reports are not a substitute for formal complaints. So a formal police report is different from a third-party report. It's not a substitute for a police report. If somebody makes a third-party report, they may still go on to do a police report if that's what they want, but no charges can be pursued through a third-party report as they would be with a police report. So if that's what someone's looking for, is to have an investigation undertaken and to potentially have charges laid against the perpetrator, then a police report would be a better option. The third-party report is a better option for people who are unsure if they want to pursue an investigation, who don't necessarily want direct contact with the police, or people who are just not sure if an investigation is the right option for them. And also important to note, if the information provided in the third-party report refers to child abuse, or if a child is in need of protection based on the information submitted in the report, agency staff do have an obligation to report this to a child welfare agency. And at that point, personal identifying information will come into play. So agency staff have a responsibility to protect personal identifying information in third-party reports, but that can only go as far as possible. As I said, if the information refers to any child abuse, or if it's suspected that there may be a child in need of protection, then that anonymity cannot be guaranteed. So another aspect of the justice system with relation to sexual assault that's not as readily discussed as I believe it should be is the Victims' Bill of Rights. Every province has their own Victims' Bill of Rights, and so the information that I have pulled for this webinar is from Manitoba's Victims' Bill of Rights. So essentially, it outlines the rights that victims and survivors of crime in Manitoba have, and it also outlines the responsibilities of duty bearers in the justice system across all aspects of the justice system. So police, courts, courtroom staff, judges, lawyers, all of those kinds of folks have responsibilities under the Victims' Bill of Rights. So the first thing that it says is that victims of crime must be treated with consideration and respect. The Victims' Bill of Rights also outlines the role of victim service workers, as in Manitoba we have the Victim Services Unit implanted directly within the court system. It explains what information victims have a right to from police, so information about charges or where the investigation is at, all of those kinds of things victims have a right to, and that is all outlined in the Victims' Bill of Rights. It details the services that are available to victims and survivors of crime and how victim service workers are supposed to help victims and survivors access those services. Specifically with respect to sexual assault cases, the Victims' Bill of Rights explains that survivors have a right to ask that they be interviewed by an officer of the same gender, and the police agency is responsible for ensuring that this request is met to the best of their ability. So this is something really important to reiterate to survivors of sexual assault, as they might not know this, and knowing this may influence whether they want to report to police or not. As outlined in the Victims' Bill of Rights, survivors actually have a right to a wealth of information about aspects of the court process, about the investigation, about compensation, and the justice system has a responsibility to provide that. Survivors have the right to request compensation through the Victims of Crime Compensation Act. Victims have a right to be heard during proceedings through the provision of a victim impact statement. So all of these things are really important for survivors and victims to know as they're going through the process, so they know what they're entitled to and can then claim those rights. Another thing that I would like to discuss is some different processes. So in situations of sexual assault, there are different processes that will be undertaken. So the police reporting process, we've already discussed third-party reporting, the medical examination process, and the court process. And it can be really helpful for survivors of sexual assault, as well as allies and advocates, to understand a little bit better these processes so that informed decisions can be made. So first, we're going to talk about the process of police reporting. So when making a formal police report, survivors are entitled to bring a support person with them. The support person can't participate in the interviewer statement process, but they can be in the room and provide emotional support. And that can be really beneficial for survivors who are doing that police report process. While talking to the police, survivors have the right to be treated with courtesy, compassion, and respect. They have the right to ask that the officer taking their statement be of the same gender as them, although with the caveat that although they are required to try their best, that request cannot always be met in certain situations. Survivors have the right to privacy, the right to ask the officer for clarity or to explain why they're asking certain questions. They have a right to take a break from questioning, to ask for an interpreter. They have a right to get transportation assistance if they have a disability or mobility issue. They have a right to be accompanied by a volunteer advocate right into the statement room. They have a right to end their statement at any time and to review the statement that they've given. After giving a statement, however, survivors will be provided with an incident number as well as the officer's name and badge number who took the statement. And these items can be really helpful for accessing the information later on or within the process of obtaining supports, whether that be through victim services or through another advocacy agency. After that report is taken, it will be sent to the Crown for review, and it is up to the Crown whether charges are laid. The police can recommend charges be laid, but it is up to the Crown to actually lay those charges against the accused. And charges are laid if there is enough evidence that a crime has been committed, and if it is deemed in the public interest to pursue charges. And I'd like to note that if there's no charges laid, it's not necessarily because the survivor isn't believed. It could be because there's not enough evidence to guarantee a reasonable chance of conviction, which unfortunately happens frequently in sexual assault cases. But again, just because there's no charges laid doesn't mean that, you know, the survivor isn't believed or that the justice system doesn't believe them. It's just, again, because there might not be enough evidence. The process of going from police report to charges laid and to that court process and sentencing could be a lengthy one. So that's something that is always good to reiterate to survivors contemplating doing this police report. Just like as an FYI, this could take quite a long time. And an advocate can help survivors with instituting safety measures and providing supports in the meantime if they do decide to undertake this process. So the court process is one that would follow from the police report process. Unfortunately, this is a process that can be overwhelming and re-traumatizing for many. And the Victims' Bill of Rights, as we briefly explained, talks about what the rights of a survivor are in this situation, as well as what the responsibilities of the court and courtroom staff are. And those rights can make it a little bit easier for survivors to be able to go through this process. So things like having access to a quiet room to go to before and after the trial, things like arranging tours of the courtroom in advance so that survivors are familiar with the environment. Those are rights that a survivor has under the Victims' Bill of Rights, and the justice system staff have a responsibility to provide those things. Typically, court hearings will take place in a community where an assault occurred, but sometimes in smaller communities, there aren't the courthouses where that can happen, so other venues might be used instead. Also important to note for the court process, the Crown is the lawyer for the state, not for the survivor, and it's important to remember that they are not the personal lawyer. The Crown will interview the survivor and ask them questions and review their statement, but they're not their lawyer. During the trial process, the burden of proof falls on the Crown. So in other words, it is up to the Crown to prove beyond a reasonable doubt that a crime did occur and that it was the accused who committed it. and the defense is the lawyer for the accused. They represent their interests during the hearing and sentencing. So essentially, the survivor does not have legal representation during a trial. They can have it if they'd like to, however, that's superfluous, really. But the Victims' Bill of Rights does state that the survivor has a right to information about the court process. They're entitled to information about what the roles of different actors are. So hopefully these things would be explained to them, but in a lot of cases, unfortunately, they're not. So we're putting them here. So the medical forensic examination is not something that's required. Survivors don't have to undertake one of those if they don't want to. It can just be an addition to the police report if survivors would like to undertake that. MFEs are completed by specially trained nurses, sexual assault nurse examiners, or SANEs, and are done at Health Sciences Center in Winnipeg. There's a special department for it within the ER where MFEs are completed. It's in a suite of rooms that's apart from the rest of the hospital in order to provide the most comfortable environment possible. The MFE is meant to collect physical and possible DNA evidence that could be used in the court process. Again, it's not necessary, but if the MFE is done and collection happens, that's what it's used for. SANEs can also facilitate the police report or third-party reporting process if the survivor would like. So in situations where the hospital is the first point of contact for survivors, the SANE would then ask the survivor if they would like to make a police report or third-party report, and then would go about making the arrangements for that to happen. So if police presence is requested, for example, they will attend in plain clothes rather than in uniform to kind of reduce the stress that comes with making a police report. They can also facilitate the third-party reporting process by having members of a third-party reporting agency in Winnipeg come down and engage in that process with the survivor. The process at the SANE facility in HSC is designed to minimize trauma and provide survivor-centered care. And all of the provisions that I've outlined are very much in line with that ethos. There's also another process that is kind of under discussed as well, and that's the advocacy process. And advocacy can be a really indispensable resource for survivors of sexual assault. And many folks might not even know that that's an option available to them outside the victim services infrastructure. So Victim Services does indeed offer advocacy services that victims and survivors of crime are entitled to under the Victims' Bill of Rights. So victim services workers may accompany survivors and witnesses to court. They could arrange tours of the courtroom in advance of the court date. They could offer a private room for the survivor and any supports they have before, during, and after the trial. So just kind of like a quiet room. They can also assist with filling out victims of crime compensation forms. Other nonprofit organizations like us, we also offer advocacy services that include some of the above, but we also offer other services as well. So we can help survivors get set up with counseling, whether that's in-house with us or somewhere else, assisting with safety planning if it's needed, helping to arrange transportation and childcare, assisting with any arrangements for medical or legal services that might be needed, accompanying survivors to the police or court, taking a third-party report, liaising with police and Crown services, and many more things. So the Women's Resource Center's approach to advocacy services is really just meeting people where they're at. So that's why I say that this is not an exhaustive list of all the things we offer. We really strive to just speak with the folks that are coming in for our services and understanding what they need and then doing those things. So if something outside of this list is needed, more than okay for us to assist them in whatever they need. And advocacy, as I mentioned, is a really indispensable resource that a lot of folks don't know exists, and it can really help to minimize the trauma of the whole police reporting, third-party reporting, and court processes. So that's what we've got for you today. I would like to note that most of the information that was in this webinar is also available in our sexual assault resource guide. Those resource guides are available at the center for anybody who would like a physical copy. You can just drop by and ask for one, or if you'd like to reach out to us by email or phone and ask for one, we'd be more than happy to set you up with as many copies as you'd like. Thank you for joining us for our webinar series today, and we'll see you next time.